Right now, we've just started the first course in the International Master in Sociology of Law last week, and the course on comparative legal cultures, which is taking place these 2 weeks, was today dealing with the subject of judging and the judiciary. So it is, and alternatives to judicial decision making. So it is very proper and very fitting that we can have this webinar precisely today. We're very lucky to have with us Rosemary Hunter, who's going to give the presentation on inclusive judging. And Sociology of Law, Sabine Frerichs, and she's going to be doing the introduction of Rosemary Hunter. So over to you, Sabine.
Thank you, José Ramón. Yeah, welcome Rosemary Hunter for this talk in our Oñati community talk series. So I think many of the people participating know you already, otherwise they would not have come. And I'm a little bit intimidated introducing you because many of you here might know you even better than I do. But anyway, I have the pleasure to introduce you. And the first thing I want to mention is that you come from, well, you are in the UK probably right now. You come from Kent Law School there. And I found that Kent Law School seems to be like a nest for socio-legal scholars. At least I know more colleagues there than anywhere else in the UK, I think. So I guess that's a good place to be. And you're presently actually the head of Kent Law School there. So you also have a say in staff management, I guess. Oh. As to your career, you started off in Australia at Australian universities with positions also on a senior level, senior lecturer, and also there Griffith University in Brisbane, you were already Dean of the Law Faculty there and Director of the Socio-Legal Research Centre. So after being very established there, then you moved to the UK in 2006, as I learned, and now you also have like positions leading in the socio-legal field, like Professor of Law and Socio-Legal Studies, and as mentioned, head of Kent Law School. As to your other positions, what I want to highlight are those which are linked with our institute, so the International Institute for the Sociology of Law. So, for example, you are a governing board member of this institute and have been so quite for a while, I think. I don't exactly know since when, but you are like a recurrent member, so to say. You are also one of the editors of a book series linked with the institute, the Oñati International series in Oñati International Series in Law and Society, it's called, I think, which has already 71 volumes, I think. And you also co-edit another book series in Law and Society with Austin Sarat, which has 6 volumes, but among them, for example, Jerry Preban's research handbook on the sociology of law, which is also was also celebrated in this forum, I think. You were also chair of an RCSL, Research Committee for the Sociology of Law working group on gender and law, and the RCSL is also one founding party of our institute. And I saw you last year last spring here at a workshop where you also gave a keynote, and the workshop was on feminist engagements with the law in contemporary Europe. So you are very close to our community, and that's probably also a reason why it was easy enough for José Ramón to invite you and get you over. No, so one of the research works which you do, so you describe yourself as a feminist socio-legal scholar, and you have different fields you focus on. So obviously then feminist perspectives, but also family justice, access to justice, judging, and the judiciary in general. But I think what you are really famous for is this feminist judgment project, or the series of feminist judgment projects where the effort is in rewriting judicial decisions from a feminist perspective. So what would a feminist judge have decided in real cases? No, and I think the talk which you will give today builds on that, like, so the title is Inclusive Judging, but I understood that it's not just about women, so feminist perspectives, but about including marginalized subjects, communities, etc., including but going beyond women. So with that, I would like to give the floor to you, and I'm very curious what you're going to share with us today.
Thank you very much, Sabina. And it's a great pleasure to be here today. And thank you for your very generous introduction. And it's great to see some of my friends from Onyati, Susanna, and Jose Ramon. It's a pleasure to be contributing in a small way to the master's program for this year. So I'll just share my screen and make sure that we can. You'll be able to see my PowerPoints. Can I just check somebody give me a thumbs up?
We can see it very well.
Okay, great. Thanks very much. Without further ado, I will jump into my talk. So I'm talking about inclusive judging, and so I'm going to begin by talking about what I mean by inclusive judging and compare inclusive judging with kind of judging as usual. And then I'm going to go on to talk about sort of two aspects of inclusive judging, so techniques of inclusive judging in mainstream court processes, but then also alternative justice processes, which take the whole aim of inclusivity further, and then finally think about the future of inclusive judging. I've got 20 minutes remaining in which to do that. Might take a little bit longer than that, but
yes, don't worry
hope
about
to leave
that.
plenty of time for questions at the end. Okay, so what do I mean by inclusive judging? So I'm starting off with theories of procedural justice, which generally talk about sort of 4 essential criteria for procedural justice, which include people having a voice, being able to participate in the process, the trustworthiness of the process, the process being neutral and transparent, and people being treated with dignity and respect. So what I'm not talking about is the first of those, the requirement of voice and participation, which is usually provided by the opportunity for litigants, usually through their lawyers, to help to frame in civil cases, decide on the issues and the argument, or in criminal cases to respond to charges that are brought against the person. So that's not what I'm talking about. What I'm focusing on is the 4th of these criteria, which is about treatment with dignity and respect, and in particular the effort to make sure that everyone is treated with dignity and respect. And so it's really the effort to ensure that the diverse circumstances, interests, life experiences of all members of society are recognised and responded to and incorporated into decision-making. So why isn't that happening already? And obviously the particular concern here is with those who have been traditionally excluded from legal subjectivity and agency on the basis of socially devalued characteristics. So that might include gender, but also race, class, and disability. So groups of people who traditionally haven't been included in legal agency. So the argument that this isn't the case, that judging as usual is not inclusive in this sense, is premised really on 2 aspects. So first of all, the fact that there's a sort of general lack of judicial diversity, and secondly, the arguments about the way in which decision-making as usual, although it claims to be neutral and objective, in fact represents a particular kind of worldview. And then also it's necessary to think about the relationship between those 2 aspects of judging as usual, and think about how one might influence the other. So in terms of judicial identity, what we know is that judiciaries everywhere don't reflect the societies that they serve. And so in particular, there's very rarely a gender balance on the bench, and obviously in many societies that is a dominance of men, and they've been the sort of traditional judges. In some societies now we see that there's a predominance of women on the bench, and again, not a parity or a gender balance. And in those cases where often European civil law systems where there is a majority of women, however, you don't see women equally represented in the court hierarchy. So they might be, the majority at the lower courts, but once you get into the higher courts, again, it's you tend to find male domination. Certainly in societies that are racially and ethnically diverse, you don't generally see that level of diversity reflected in the judiciary. And it's also the case that just about everywhere that judges come from a particular class and a particular elite educational background, which is not representative or reflective of the majority of society. And so then that's a question, well, how does judicial identity impact on decision making? And in theory, so there's a sort of theory about judicial method, is that this should make the identity of the judge is irrelevant, that judicial method, the processes of judging kind of insulate the process from any contamination, if you like, by the identity of the judge, because all judges will judge, there's an accepted method of judging, and that method means that all judges will, whoever they are, will judge in the same way. We know that that's the theory. We also know that in some ways that's a sort of legitimating story that law tells about itself, but that in practice, there are all sorts of ways in which the identity of the judge is going to be relevant. We see it reflected in legal doctrines, reflecting a particular worldview, in the kind of everyday judgments that judges make in terms of assessing the credibility of witnesses, understanding the facts, exercising their discretion, managing the courtroom. All of those sort of everyday micro decisions that judges might be making are likely to reflect their judicial background. So a credible witness is someone who behaves in a way or thinks in a way that is plausible to somebody from that judge's background. The way that judges will understand the facts will be inflected by their own personal life experience. The way that they exercise discretion will be, in accordance with a set of norms that they have imbibed from their sort of judicial background. In managing the courtroom, they may or may not be thinking about or attentive to the experiences of people who are not insiders in the legal system. So that then raises the question, if we had a more diverse judiciary, would that simply automatically result in more inclusive judging? And the answer to that question, and there's been quite a lot of empirical research done on this question, and the answer is kind of equivocal, like not necessarily. So there are a number of things that might prevent an individual judge, even from a non-traditional background, from taking a more inclusive approach in their judging. So one of them is obviously the kind of judicial socialization. So the legal training that they have received, the judicial training that they have received, the judicial culture in which they now find themselves, exercises very strong normative force in deciding in the way that things have always been done. And so there's a certain discouragement or disapproval of doing something different, and certainly sort of introducing one's identity in a way that might lead to a different approach to the courtroom or to decision making. So that's the kind of normative context in which the judge is operating. They might well, being an outsider, being a non-traditional, being from a non-traditional background, but having achieved a certain level of seniority as a judge, be wanting to fit into the judiciary. I mean, this might well be part of their own kind of social mobility project, which is to become a judge in the same way, in the sort of accepted way in which judges normally behave. But conversely, there's also, I think, certainly judges from non-traditional backgrounds, or when the first women judges were appointed, found themselves subject to a set of additional pressures and scrutiny of their judicial behaviour, because there was a kind of assumption that they wouldn't be sufficiently qualified, that they would be different, that they might not judge in the accepted way, and so they were subjected to sort of levels of pressure and scrutiny to encourage them to conform to judging as usual. And so what the research suggests is that for a non-traditional judge to take a different approach, to try to be more inclusive, to think about the law and the facts and the way that they manage the courtroom differently, actually takes quite a lot of determination and sort of conscious determination to do. And also they have to have the opportunity to do that, and perhaps also the encouragement to do that. So, for example, there's some quite interesting work being done, comparing sort of a more traditional legal system like the one in the UK with that in post-apartheid South Africa, where there was a sort of positive encouragement for judges to do things differently, for judges to leave behind the discriminatory and apartheid past, and to be consciously more inclusive in the way that they engaged in judging. And so it's a very different atmosphere from that in which there's a sort of more traditional contexts where judges might find themselves actively discouraged from doing something different. So there are all sort of reasons why, even with a more diverse judiciary, that might not have much of an effect, or as much effect as you might assume, on changing judicial practices and judicial culture. On the other hand, what the American political science research has found is what's called panel effects. So it's looking at the ways in which collegial courts operate, collegial courts that are made up of a purely like all men or all white people, versus and what is there any difference if a woman or a black person is introduced onto that court? And what that research suggests is that there are quite strong panel effects from a more diverse judiciary. So as if there is one person who is different on the court does tend to decide differently. And the sort of explanation that is put forward to that is that the court is being given, has a better range of information before it in order to make its decision, is being given different perspectives and thinking about things perhaps in ways that they haven't traditionally been thinking about things, and that's sometimes leading to a different conclusion. So there you might see non-traditional judges having an influence behind the scenes, so it's not necessarily obvious in the way that they write their judgment or in the way that they run their courtroom, but in the kind of judicial conversations that occur in private spaces, that there is an influence that is seen there. So, as I said, there's kind of equivocal evidence about the effects of a more diverse judiciary having a greater gender and racial representation in the judiciary, but we can't necessarily assume that that's going to make a difference by itself. So when we're looking at the ways in which, and some of my research has been involved in documenting and analysing examples of inclusive judging. So obviously we can look at, there have been some case studies and observational studies of non-traditional judges in the real world and how they have conducted their judicial practice. But we also have, as Sabina mentioned, the sort of feminist and other critical judgment rewriting projects, which have, I suppose, hypothetically engaged in more inclusive judging by sort of thinking, how would a feminist judge or a non-white judge sitting on the bench at the same time as the original court and deciding with the same material that was in front of the original court, would they have decided differently? What additional perspectives and understandings might they bring to this particular case, which might lead to a different result? And so that's those exercises, and there have been quite a lot of them. There's feminist judgment projects all over the world, and a number of other critical judgment rewriting projects, critical race judgments, children's rights judgments, human rights judgments. There's been some more generally critical judgments. So there's quite a lot of material there now, both in the sort of imaginary world of critical judgment writing and in the real world of observational studies and case studies. So there's sort of enough material there now to be able to identify a range of different techniques that might typically be used in order to judge more inclusively. So one of those things would be the judge referring to a wider range of legal materials than just the sort of immediate precedents or legislation. And that's often perhaps international legal materials, perhaps international legal conventions, the CEDAW Convention or the Convention on the Rights of the Child, or other material decisions from other jurisdictions that might be persuasive, if not binding on the court, but that just bring a broader perspective to the issues at hand and show different ways in which they might be decided. Another thing is being very attentive to context and to the social context in which the law has been enacted and in which the facts have played out. So rather than, sort of judicial method tends towards abstraction. It sort of abstracts the facts and the issues from a wider context in order to make decisions, in order to apply the law to them in a way that would be replicable in any other context. But the sort of inclusive judging tends to be more attentive to the context, and then enables the court to see both the law and the facts and the implications of the decision, and the implications of the way that the law is currently configured for particular social groups. So that's a sort of key technique that's been identified. Where the court has the capacity to do so, revising legal doctrine to ensure that it is more inclusive, to ensure that the experiences of a wider range of people are taken into account. Or certainly many courts don't have the capacity to revise legal doctrine unless they're at the very top of the court hierarchy. But there are ways in which a court might interpret doctrine more inclusively, to extend to different kinds of fact situations, or to understand the words and the language of a statute in a way that gives it a particular kind of remedial purpose rather than interpreting it narrowly. Certainly expanding the range of knowledge that's taken into account, weighing up discretionary factors differently. So when judges are exercising discretion, there's often a range of factors that they have to take into account in thinking about how they're going to exercise that discretion. So you might give different weight to those different factors, and perhaps in light of the particular litigants before the court and their life experiences. Another technique that has emerged as a really sort of key element of the feminist and critical judgment writing projects is understanding the facts differently. So and telling what we call telling the story differently. So often when we're reading cases, the facts are often just taken for granted. They're presented, they say this is the facts, and then let's go on to thinking about how the law applies to them, and or how we interpret the law in order to apply to the facts. But the facts themselves, one of the sort of insights from these judgment rewriting projects is the way in which the facts are constructed, and that the construction of the facts has a really important impact on the way in which the law is applied to them, and the way in which the law operates. And so often the rewritten judgments have involved not necessarily any change in the law, but simply telling the story differently, bringing in more information, understanding what happened from the perspective of a marginalised litigant rather than from the perspective of the respondent, the repeat player respondent. I mean, I think it's been quite interesting to us to read sometimes decisions where you've got an initial decision and then appeal judgment and then perhaps a second appeal, and the way in which the court describes the facts in different ways, emphasising certain elements or sidelining certain elements in order to set up the legal conclusion that they want to reach. And so often the sort of more inclusive approach is to go back and think about, right, how would you tell this story in such a way that it actually included and recognised and acknowledged the experience of the sort of marginalised litigants. And as part of that, obviously, not falling into stereotypes, resisting both conscious and unconscious biases about people's behaviour and people's decision-making. And a particular example of this is where, in cases involving violence, often violence against women or racist violence, is not kind of euphemising or minimising the suffering that people have been subjected to. So naming violence, responding to it appropriately, understanding and naming trauma and understanding the effects of trauma on people's ability to participate in the court proceedings or give evidence. You know, sometimes people's evidence might be judged as not being very credible because their story was not coherent, or they told a different story to the police to what they said in court. But often that is a result of the trauma of that they've been subjected to through their experience, and then the court process, you know, is re-traumatizing. And so understanding that puts a very different spin on your understanding of the credibility of the witness. And then also, you know, being aware of structural discrimination and not blaming people or holding people responsible for things that they couldn't, that they have no control over. So some other techniques. Not being a passive judge, so actively seeking information in order to reach a just decision, actively asking about, for example, in criminal sentencing, asking about the defendant's circumstances rather than just relying on the information that comes to the court, managing the courtroom in a way that protects vulnerable parties, making sure that people who are outsiders who might be feeling uncomfortable or alienated, that the process is explained to them, that they know what's going on, that having the judge directly interacting with parties rather than only sort of talking to their lawyers, demonstrating empathy and compassion for people's life circumstances. And then when we're getting into the actual decisions that are made, making perhaps more creative dispositions and remedies. So some of the feminist judgments have involved, and some of the other judgments have involved thinking, well, you know, there's not much that we can do in terms of providing the remedy that the person might want, but we can provide some guidelines for what should happen in future cases, or in a couple of cases, making an apology on behalf of the court or on behalf of the justice system for historical injustices that have occurred and that, you know, that can't be adequately remedied in other ways. Writing judgments in a ways that shows that the participants have been heard, treating them respectfully, directly addressing, for example, in sentencing cases, directly addressing the family of the victim and referring to their victim impact statement, and, you know, saying that the judge understands how they feel and how traumatic this whole experience has been for them. Communicating judgments in different ways. So there's been